Hi, I'm Professor Tracey McCants Lewis. My current research is dealing with legal storytelling. I'm specifically looking at the use of legal storytelling in relationship to the Pennsylvania voter ID law. In 2012, Pennsylvania was one of many states that enacted a voter ID law to prevent in-person voter fraud. This law specifically required Pennsylvania registered voters to provide very specific forms of identification, picture identification, that would prove that they are who they are before they could cast a vote. Some of the specific IDs were driver's license, a current passport, military ID, or a college ID. But if an individual didn't have that specific ID, they were required then to provide additional information to prove their identification to get a free Pennsylvania voter ID identification that could be used at the polls. Those additional documents included things like a birth certificate with a raised seal, or a social security card, marriage license. These requirements proved to be very challenging for certain populations within the Commonwealth of Pennsylvania. That included females who had change of name, or minorities, the elderly, and specifically minority African Americans and the poor. So based upon this potential disenfranchisement of these populations, there was a coalition, a grassroots coalition of many organizations that formed together to, number one, educate people on the new law, and specifically, number two, to identify individuals that would likely be disenfranchised by the law. And through these grassroots efforts, they used traditional forms of grassroots work. They used in-person meetings, they used print, radio, television, but then they also used new forms of grassroots work. They went out and used Twitter, they used Facebook and YouTube to take the stories of individuals that would be likely be disenfranchised by the law. And my theory is that the use of legal storytelling to get out information to the public, to the legislature, to the courts about individuals that were going to be disenfranchised, in fact, changed the complexion, it changed the nature of the law. The law that was enacted in March of 2012 in no way, shape, or form really looks like the law that we have on the books right now. And in addition, the use, I believe, of legal storytelling also had an impact on the court. The court has, in fact, since March of 2012, not permitted the law to go through. There is an injunction that's still in place, and the law, as it was enacted, has not been enforced through any of the elections since 2012. And it's my belief that the use of legal storytelling is why that's occurred.